Today I am going to start another chapter of our constitution, that is the union executive, and the subject is the president and the vice president. At the head of the union executive stands the president of India. The president of India is elected by indirect election, that is by an electoral college in accordance with the system of proportional representation by means of the single transferable vote. The electoral college shall consist of the elected members of both houses of parliament, B. the elected members of legislative assemblies of the states, and C. the elected members of the legislative assemblies of union territories of Delhi and Pondicherry. As far as practicable, there shall be uniformity of representation of different states at the election according to the population and the total number of elected members of the legislative assembly of each state, and parity shall also be maintained between the states as a whole and the union. The second condition seeks to ensure that the votes of the states in the aggregate in the electoral college for the election of the president shall be equal to that of the people of the country as a whole. In this way, the president shall be a representative of the nation as well as a representative of the people in the different states. It also gives recognition to the status of states in the federal system. The system of indirect election was criticized by some as falling short of the democratic ideal underlying universal franchise, but indirect election was supported by the framers of the constitution on the following grounds. Direct election by an electorate of some 510 millions of people would mean a tremendous loss of time, energy and money. Under the system of responsible government introduced by the constitution, real power would waste in the ministry, so it would be anomalous to elect the president directly by the people without giving him real powers. In order to be qualified for election as president, a person must be a citizen of India, have completed the age of 35 years, be qualified for election as a member of the House of the People, and must not hold any office of profit under the government of India or the government of any state or under any local or other authority subject to the control of any of the state government, but a sitting president or vice president of the union or the governor of any state or a minister either for the union or for any state is not disqualified for election as president. Article 58. The president's term of office is 5 years from the date on which he enters upon his office, but he is eligible for re-election. Article 57 to 57. The president's office may terminate within the terms of 5 years in either of two ways: by resignation in writing under his hand addressed to the Vice President of India, by removal for violation of the Constitution by process of impeachment. Article 56. The only ground for impeachment is specified in Article 61(1) is violation of the Constitution. An impeachment is a quasi-judicial procedure in Parliament. Either House may prefer the charge of violation of Constitution before the other House, which shall then either investigate the charge itself or cause the charge to be investigated. But the charge cannot be preferred by a House unless a resolution containing the proposal is moved after a 14 days notice in writing signed by not less than 1/4 of the total number of members of that house. The resolution is then passed by a majority of not less than 2/3 of the total membership of the house. The president shall have a right to appear and to be represented at such investigation if as a result of the investigation a resolution is passed by not less than 2/3 of the total membership of the house before which the charge has been preferred, declaring that the charge has been sustained, such resolution shall have the effect of removing the President from his office with effect from the date on which such resolution is passed. Article 61. Since the Constitution provides the mode and ground for removing the President, he cannot be removed otherwise than by impeachment in accordance with the terms of Article 56 and 61. The President shall not be a member of either House of Parliament or the House of the Legislature of any state, and if a member of either House of Parliament or of a House of the Legislature of any state be elected President, he shall be deemed to have vacated his seat in that House on the date on which he enters upon his office as President. The President shall not hold any office of profit. Article 59(1). The President shall be entitled without payment of rent or to the use of his official residence, and shall be also entitled to such emoluments, allowances, and privileges as may be determined by Parliament by law, and until provision in that behalf is so made, such emoluments, allowances, and privileges as are specified in the second schedule of the Constitution. By passing the President's Emoluments and Pension Amendment Act 1998, Parliament has raised the emoluments to rupees 50,000 per mensem. The emoluments and allowances of the President shall not be diminished during his term of office. Article 59(3). The Amendment Act 1998 referred to above also provides for the payment of an annual pension of rupees 3 lakh to a person who held office as President on the expiration of his term or on resignation, provided he is not re-elected to the office. A vacancy in the office of the President may be caused in any of the following ways: on the expiry of his terms of 5 years, by his death, by his resignation, on his removal by impeachment, otherwise as for example on the setting aside of his election as President. Article 65(a). When the vacancy is going to be caused by the expiration of the terms of the sitting President, an election to fill the vacancy must be completed before the expiration of the term. Article 62(1). But in order to prevent an interregnum owing to any possible delay in such completion, it is provided that the outgoing President must continue to hold office notwithstanding that his term has expired until his successor enters upon his office. Article 56(1)(c). There is no scope for Vice President getting a chance to act as President in this case. In the case of a vacancy arising by reason of any cause other than the expiry of the term of the incumbent in office, an election to fill the vacancy must be held as soon as possible after, and in no case later than 6 months from the date of occurrence of the vacancy. Immediately after such vacancy arises, say by the death of the President, and until a new President is elected, as above, it is Vice President who shall act as President. Article 65(1). It is needless to point out that the new President who is elected shall be entitled to the full term of 5 years from the date he enters upon his office. Apart from a permanent vacancy, the President may be temporarily unable to discharge his functions owing to his absence from India, illness, or any other cause, in which case the Vice President shall discharge his function until the date on which the President resumes his duties. Article 65(2). The election of Vice President, like that of President, shall be indirect in accordance with the system of proportional representation by means of single transferable vote, but his election shall be different from that of President inasmuch as the state legislature shall have no part in it. The Vice President shall be elected by an electoral college consisting of members of both houses of Parliament. Article 66(1). As in the case of President, in order to be qualified to be elected as Vice President, a person must be a citizen of India over 35 years of age, must not hold an office of profit save that of president, vice president, governor, and minister for the union or a state. But while in order to be a president, a person must be qualified for election as a member of the House of the People, in order to be vice president, he must be qualified for election or as a member of Council of States. The reason for this difference is obvious, namely that the vice president is normally to act as the chairman of the Council of States. There is no bar to a member of the union or a state legislature being elected president or vice president, but the two offices cannot be combined in one person. In case a member of the legislature is elected president or vice president, he shall be deemed to have vacated his seat in that house of legislature to which he belongs on the date on which he enters upon his office as president or vice president. Article 59(1), 66(2). The term of office of vice president is 5 years. His office may terminate earlier than the fixed term, either by resignation or by removal. A formal impeachment is not required for his removal. He may be removed by a resolution of Council of States passed by a majority of its members and agreed to by the House of People. Article 67, provision B. Though there is no specific provision corresponding to Article 57 making the Vice President eligible for re-election, the explanation to Article 66 suggests that a sitting Vice President is eligible for re-election, and Dr. S. Radhakrishnan was in fact elected for a second term in 1957. The Vice President is the highest dignitary of India, coming next after the President. No functions are, however, attached to the office of the Vice President as such. The normal function of the Vice President is to act as the ex officio chairman of Council of States. But if there occurs any vacancy in the office of the President by reason of his date, resignation, removal, or otherwise, the Vice President shall act as President until a new President is elected and enters upon his office. The Vice President shall discharge the functions of the President during the temporary absence of the President, illness, or any other cause by reason of which he is unable to discharge his function. Article 65(2). No machinery having been prescribed by the Constitution to determine when the President is unable to discharge his duties owing to absence from India or like cause, it becomes a somewhat delicate matter as to who should move in the matter on any particular occasion. It is to be noted that this provision of the Constitution has not been put into use prior to 20th June 1960, though President Dr. Rajendra Prasad has been absent from India for a considerable period during his foreign tour in the year 1958. It was during the 15-day visit of Dr. Rajendra Prasad to the Soviet Union in June 1960 that for the first time the Vice President Dr. Radhakrishnan was given the opportunity of acting as Vice President owing to the inability of President to discharge his duties. The second occasion took place in May 1961 when President Dr. Rajendra Prasad became seriously ill and incapable of discharging his functions. After a few days of crisis, the President himself suggested that the Vice President should discharge the function of the President and until he resumed his duties. It appears that the power to determine when the President is unable to discharge his duties or when he should resume his duties has been understood to belong to the President himself. In the event of occurrence of vacancy in the office of both the President and Vice President by reason of death, resignation, removal, etc., the Chief Justice of India, or in his absence, the senior most judge of Supreme Court available shall discharge the function until a new President is elected. In 1969, when on the death of Dr. Zakir Hussain, the Vice President, Sri V.V. Giri resigned, the Chief Justice Sri Hridayatullah discharged the functions from 27/1969. When the President acts as or discharges the function of the President, he gets the emoluments of President, otherwise he gets the salary of the Chairman of the Council of States. When the Vice President thus acts as or discharges the function of the President, he shall cease to perform the duties of Chairman of the Council of States. Then the Deputy Chairman of the Council of States shall act as its Chairman. Determination of doubts and disputes relating to the election of a President or Vice President is dealt with in Article 71 as follows. Such disputes shall be decided by Supreme Court, whose jurisdiction shall be exclusive and final. No such dispute can be raised on the ground of any vacancy in the Electoral College which elected the Vice President or Vice President, if the election of a President or Vice President is declared void by the Supreme Court. Acts done by him prior to the date of such decision of the Supreme Court shall not be invalidated. Barring the decision of such disputes, other matters relating to the election of President or Vice President may be regulated by law made by Parliament. Powers and duties of President. The Constitution says that the executive power of Union shall be vested in the President. Article 53, the President of India shall thus be the head of the executive power of the Union. The executive power primarily means the execution of laws enacted by the legislature, but the business of the executive in the modern state is not as simple as it was in the days of Aristotle. Owing to the manifold expansion of the functions of the state, all residuary functions have practically passed into the hands of executive. The executive power may therefore be shortly defined as the power of carrying on the business of government or the administration of affairs of the state. Expecting functions which are vested by the Constitution in any other authority, the ambit of the executive power has been thus explained by our Supreme Court. It may not be possible to frame an exhaustive definition of what executive function means and implies. Ordinarily, executive power connotes the residue of governmental function that remain after legislative and judicial functions are taken away, subject of course to the provision of Constitution or of any law. The executive function comprises both the determination of the policy as well as carrying it into execution, the maintenance of order, the promotion of social and economic welfare, the direction of foreign policy, in fact carrying on or supervision of general administration of the state. Before we take up an analysis of the different powers of Indian President, we should note the constitutional limitations under which he is to exercise his executive powers. Firstly, he must exercise these powers according to the Constitution, Article 53(1). Thus, Article 75(1) explicitly requires that ministers other than the Prime Minister can be appointed by the President only on the advice of Prime Minister. There will be a violation of this provision if the President appoints a person as minister from outside the list submitted by the Prime Minister. If the President violates any of the mandatory provisions of the Constitution, he will be liable to be removed by the process of impeachment. Secondly, the executive powers shall be exercised by the President of India in accordance with the advice of his Council of Ministers. Article 74(1). Prior to 1976, there was no express provision in the Constitution that the President was bound to act in accordance with the advice tendered by the Council of Ministers. Though it was judicially established that the President of India was not a real executive but constitutional head who was bound to act according to the advice of ministers so long as they command demanded the confidence of the majority in the House of the People, Article 75(3). The 42nd Amendment 1976 amended Article 74(1) to clarify this position. Article 74(1) as so amended reads, "There shall be a Council of Ministers with the Prime Minister at the head to aid and advise the President, who shall in the exercise of his function act in accordance with such advice." The word "shall" makes it obligatory for the President to act in accordance with ministerial advice. The Janata government retained the foregoing text of Article 74(1) as amended by the 42nd Amendment Act, but by the 44th Amendment Act, the proviso was added to Article 74(1) as follows: provided that the President may require the Council of Ministers to reconsider such advice either generally or otherwise, and the President shall act in accordance with the advice tendered after such reconsideration. The net result after the 44th Amendment, therefore, is that, except in certain marginal cases referred to by the Supreme Court to be notified presently, the President shall have no power to act in his discretion in any case. He must act according to the advice given to him by the Council of Ministers headed by the Prime Minister, so that refusal to act according to such advice will render him liable to impeachment for violation of Constitution. This is subject to the President's power to send the advice received from the Council of Ministers in a particular case back to them for their reconsideration, and if the Council of Ministers adhere to their previous advice, the President shall have no option but to act in accordance with such advice. The power to return for reconsideration can be exercised only once on the same matter. It may be said accordingly that the powers of the President will be the powers of his ministers in the same manner as the prerogatives of the English Crown have become the privilege of the people. An inquiry into the powers of Union government, therefore, presupposes an inquiry into the provisions of Constitution which vest power and functions in the President. The various powers that are included within the comprehensive expression executive power in a modern state have been classified by political scientists under the following heads: administrative power, that is the execution of the laws and the administration of departments of government; military power, that is the command of the armed forces and the conduct of war; legislative power, that is the summoning, prorogation, etc. of the legislature, initiation of the assent to legislation, and the like; judicial power, that is granting of pardons, reprieves, etc. to persons convicted of crime. The Indian Constitution, by its various provisions, bests power in the hands of the President under each of these heads, subject to the limitations just mentioned. The administrative power in the matter of administration, not being a real head of the executive like the American President, the Indian President shall not have any administrative function to discharge, nor shall he have that power of control and supervision over the departments of the government as the American President possesses. But though the various departments of the government of the Union will be carried out under the control and responsibility of the respective ministers in charge, the President will remain a formal head of the administration, and as such all executive action of the Union must be expressed to be taken in the name of President. The only mode of ascertaining whether an order or instrument is made by the government of India will be to see whether it is expressed in the name of the President and authenticated in such manner as may be prescribed by rules to be made by the President, Article 77. For the same reason, all contracts and assurances of property made on behalf of the government of India must be expressed to be made by the President and executed in such manner as the President may direct or authorize Article 299. Again, though he may not be the real head of administration, all officers of the Union shall be his subordinates, Article 53(1), and shall have a right to be informed of the affairs of the Union, Article 78(b). The administrative power also includes the power to appoint and remove the high dignitaries of the state. Under our Constitution, the President shall have the power to appoint the Prime Minister of India, other ministers of Union, the Attorney General of India, the Comptroller and Auditor General of India, the judges of Supreme Court, the judges of High Court of the states, the governor of a state, a commission to investigate interference with water supplies, the Finance Commission, the Union Public Service Commission and Joint Commission for a group of states, the Chief Election Commissioner and other members of the Election Commission, a special officer for the scheduled caste and scheduled tribes, a commission to report on the administration of scheduled areas, a commission to investigate into the condition of backward classes, a commission on official language, a special officer for linguistic minorities. In making some of the appointments, the President is required by the Constitution to consult persons other than his ministers as well. Thus, in appointing the judges of Supreme Court, the President shall consult the Chief Justice of India and such other judges of the Supreme Court and of the High Courts as he may deem necessary. Article 124(2). These conditions will be referred to in the proper places in connection with the different offices. The President shall have also the power to remove his ministers individually, the Attorney General for India, the Governor of State, the Chairman or a member of the Public Service Commission of the Union or of a state on the report of the Supreme Court, a judge of the Supreme Court or of a High Court or Election Commissioner on an address of Parliament. This is all about today's the Union Executive. Thanks, regards.